I note that this is the moment in which the White House would have had an opportunity to question the witnesses, but they declined our invitation. So we will now proceed to questions under the 5-minute rule. I yield myself 5 minutes for the purpose of questioning the witnesses. Professor Feldman, would you respond to Professor Turley's comments about bribery, especially about the relevance of the elements of criminal bribery?
Yes. Bribery had a clear meaning to the framers. It was when the president, using the power of his office, solicits or receives something of personal value from someone affected by his official powers. And I want to be very clear. The Constitution is law. The Constitution is the supreme law of the land. So of course, Professor Turley is right. You wouldn't want to impeach someone who didn't violate the law. But the Constitution, the supreme law of the land, specifies bribery as a ground of impeachment, as it specifies other high crimes and misdemeanors. Bribery had a clear meaning. If the House believes that the president solicited something of value in the form of investigations or an announcement of investigations, and that he did so corruptly for personal gain, then that would constitute bribery under the meaning of the Constitution, and it would not be lawless. It would be bribery under the law.
So the Supreme Court case in McDonnell interpreting the federal bribery statute and other decisions interpreting the statutes would not be relevant.
The Constitution is the supreme law, and the Constitution specifies what bribery means. Federal statutes can't trump the Constitution. They can't defeat what's in the Constitution.
Thank you. Professor Gerhardt, would you respond to Professor Turley's comments about obstruction of justice or obstruction of Congress, please?
Yes. On obstruction of justice, one thing I want to emphasize is obstruction of justice is not just about obstruction of a court. It's obstruction of any lawful proceeding. And so that obstruction isn't limited to whatever is happening on the courts. And obviously here, there are judicial proceedings going on, but there's also a really critical congressional proceeding, which brings us to obstruction of Congress. And with the obstruction of Congress, I don't think, in fact, I can say, I know there's never been anything like the president's refusal to comply with subpoenas from this body. These are lawful subpoenas. These have the force of law to them. These are the things that every other president has complied with and actually acted in alignment with, except for President Nixon in a small but significant set of materials.
Professor Turley implied that as long as the president asserts a fanciful, ultimately non-existent privilege like absolute immunity, he can't be charged with obstruction of Congress because, after all, it hasn't gone through the courts yet. Would you comment on that? Professor Gerhardt?
I'm sorry, I missed part of the question. Please, I'm sorry.
Professor Turley implied that we can't charge the president with obstruction of Congress for refusing all subpoenas as long as he has any fanciful claim until the courts reject those fanciful claims.
I have to respectfully disagree. No, his refusal to comply with those subpoenas is an independent event. It's apart from the courts. It's a direct assault on the legitimacy of this inquiry, which is crucial to the exercise of this power.
Thank you, Professor Carlin. I'll give you a chance to respond, if you would like, as well, to the same question.
I wanted to respond to the first question about bribery, if I could instead, which is, although counsel for the minority read Samuel Johnson's definitions of high and crime and misdemeanor, he didn't read the definition of bribery. Now, I have the 1792 version of Johnson's dictionary. I don't have the initial one. And there he defines bribery as the crime of giving or taking rewards for bad practices. And so if you think it's a bad practice to deny military appropriations to an ally that have been given to him, if you think it's a bad practice not to hold a meeting to buck up the legitimacy of a government that's on the front line, and you do that in return for the reward of getting help with your reelection, that's Samuel Johnson's definition of bribery.
Thank you. And Professor Feldman, if Washington were here today, if he were joined by Madison, Hamilton, and other framers, what do you believe they would say if presented with the evidence before us about President Trump's conduct?
I believe the framers would identify President Trump's conduct as exactly the kind of abuse of office, high crime and misdemeanor that they were worried about, and they would want the House of Representatives to take appropriate action and to impeach.
And they would find obstruction of justice, obstruction of Congress, and abuse of power, or some of them?
I believe that if the evidence supported those things in their minds, and if Congress determines that that is what the evidence means, then they would believe strongly that that's what Congress ought to do.
Thank you. I'll yield back my time, the balance of my time. I'll now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for 5 minutes for questioning the witnesses.
This just keeps getting more amazing. I think we just put in the jury pool the founding fathers and said, what would they think? I don't think we have any idea what they would think, in all due respect, with this, because of the different times, the different things we've talked about, but also to in some way insinuate on a live mic with a lot of people listening that the founding fathers would have found President Trump guilty is just simply malpractice in this with these facts before us. That is just simply pandering to a camera. That is simply just not right. I mean, this is amazing. We can disagree. What's amazing on this committee is we don't even disagree on the facts. We cannot even find a fact right now where it is not going through the public testimony and also even the transcripts and all. It is not. Mr. Charlie, are we going to deputize somebody between now and the founders into the jury pool here?
Well, first of all, only I will speak for James Madison. No, we all will speak for James Madison with about the same level of accuracy. It's a form of necromancy that academics do all the time, and that's what we get paid for. But I just want to note a couple of things. First of all, I do find it rather surprising that you would have George Washington in this jury pool. I would strike him for cause. George Washington was the first guy to raise extreme executive privilege claims. He had a rather robust view of what a president could say. If you were going to make a case to George Washington that you could impeach over a conversation he had with another head of state, I expect his hair, his powdered hair, would catch on fire. Also, I just want to know one other thing. And I am impressed with carrying an 18th century copy of Samuel Johnson with you.
No, it's just the online version.
It's just the online version. You, as an academic, I was pretty darn impressed. I just want to note one thing which may explain part of our difference. The statutes today on bravery are written broadly, just like they were back then. That was my point. The meaning of those words are subject to interpretation. They're written broadly because they don't want them to be too narrow. That was the case in the 18th century as they are today. But the idea that bad practices could be the definition of bribery, really? I mean, is that what you get from the Constitutional Convention, that bad practices? Is that why Mason wanted to put in maladministration? Because bad practices is not broad enough? This is where I disagree. Now, the other thing that I just wanted to note is, and I have so much respect for Noah, and I'm going to just disagree on this point. I feel it is a rather circular argument to say, well, the Constitution is law. Upon that, we are in agreement. But the Constitution refers to a crime. To say, well, you can't trump the Constitution because it defines the crime. It doesn't define the crime. It references the crime. Now, the examples were given during the Constitutional Convention, and those do not comport with bad practices. They comport with real bribery. But to say that the Supreme Court's decision on what constitutes bribery is somehow irrelevant is rather odd. What the Constitution contains is a reference to a crime, and then we have to decide if that crime has been committed.
Well, and I think one of the things that came out just a second ago was also this discussion of, and we had this discussion earlier about, is it the presidential prerogative and also members of the president's cabinet to assert privileges and rights. And we talked about the fast and furious with President Obama. Remember, Attorney General Holder was held in contempt by this body for withholding and not complying with subpoenas. I mean, you just can't pick and choose history here with what you want to have. But I think also you just made a statement, and it was brought up earlier, talking about bad practice. It is also the law of the land that we are supposed to ensure that countries given aid are not corrupt. And I think this is also something that's missing from this discussion as well. If the president has had a long-seated distrust of foreign companies, especially Ukraine and others, with a history of corruption. I made this statement earlier. It's in the report from the HIPSI side on our side. 68% of those polled in the Ukraine over the previous year had bribed a public official. Ukraine had corruption issues. It came back from the Obama administration, came through the Trump administration, and our rule is that they have to actually look at the corruption before giving taxpayer dollars. The president was doing that, and now it has been blown up because we've now found in this hearing today, facts really don't matter if we're trying to fit it into a law or fitting it into a breaking of rule that we want to impeach on. And as I've said, the reason we're doing this is the train is on the track. This is a clock calendar impeachment, not a fact impeachment. I yield back.
Gentleman yields back. I now recognize Ms. Lofgren for 5 minutes.
Thank you, Mr. Chairman. This is, as has been mentioned, only the third time in modern history that the committee has assumed the grave responsibility of considering impeachment. And oddly enough, I've been present at all three. I was staff of Congressman Don Edwards during the Nixon impeachment, present on the committee during the Clinton impeachment, and here we are today. At its core, I think the impeachment power really is about the preservation of our democratic systems. And the question we must answer is whether the activity of the president threatens our Constitution and our democracy. And it's about whether he's above the law and whether he's honoring his oath of office. Now, the House Judiciary Committee staff, and it wasn't me, it was other staff, wrote an excellent report in 1974, and this is what they said. Impeachment of a president is a grave step for the nation. It is to be predicated only upon conduct seriously incompatible with either the constitutional form and principle of our government or the proper performance of constitutional duties of the presidential office. And I'd ask unanimous consent to enter the House Judiciary Committee report on constitutional grounds into the record. Thank you, Mr. Chairman. You know, like President Nixon, the allegations against President Trump involve serious election-related misconduct. Nixon's associates burglarized the DNC headquarters to give him a leg up in his election. Nixon tried to cover up the crime by obstructing federal and congressional investigations. He also abused his powers to target his political rivals. And here we're confronted with evidence suggesting that President Trump tried to leverage appropriated military assistance to resist Russia by Ukraine to convince a foreign ally to announce an investigation of his political rival. Professor Carlin, I'd like you to tell me your view on how President Trump's conduct, meeting his request of the foreign ally to announce an investigation of his adversary, how does that compare to what President Nixon did?
Not favorably. Because as I suggested in my opening testimony, it was a kind of doubling down because President Nixon abused domestic law enforcement to go after his political opponents. And what President Trump has done, based on the evidence that we've seen so far, is he's asked a foreign country to do that, which means it's not. It's sort of like a daily double, if you will,
right,
of problems.
Professor Gebhardt, do you have an additional comment on that?
I certainly would agree with Professor Carlin. Yes, I think the difficulty here is we need to remember that impeachable offenses don't have to be criminal offenses, as you well know. And so what we're talking about is an abuse of power. And we're talking about an abuse of power that only the president can commit. And there was a systematic, concerted effort by the president to remove people that would somehow obstruct or block his ability to put that pressure on Ukraine to get an announcement of an investigation. That seems to be what he cared about.
We want to pause briefly to welcome our viewers from our CBS stations. Hi, everyone. I'm Rena Ninen in New York, continuing our CBSN special report. We take you back now to the hearing.
As we saw in the Myers case, and I was a member of the committee when we tried to get her testimony, as well as the Fast and Furious case, which also was wrongfully withheld from the Congress, litigation to enforce congressional subpoenas can extend well beyond the terms of the presidency itself. That happened in both of those cases. Professor Feldman, is it, as Professor Turley seemed to suggest, an abuse of our power not to go to the courts before using our sole power of impeachment in your judgment?
Certainly not. Under the Constitution, the House is entitled to impeach. That's its power. It doesn't have to ask permission from anybody, and it doesn't have to go through any judicial process involving the judicial branch of government. That is your decision based on your judgment.
Thank you. I'd just like to note that this is not a proceeding that I looked forward to. It's not an occasion for joy. It's one of solemn obligation. I hope and believe that every member of this committee is listening, keeping an open mind, and hoping that we honor our obligations carefully and honestly. And with that, I yield back, Mr. Chairman.
The gentlelady yields back. The gentlelady yields back. We are expecting votes on the House floor shortly, so we will recess until immediately after the conclusion of those votes. I ask everyone in the room to please remain seated and quiet while the witnesses exit the room. I want to remind members of the audience that you may not be guaranteed your seat if you leave the hearing room at this time. At this time, the committee will stand in recess until immediately after the votes.